we talked about.
All right, you are Robert Isaiah Paredes?
Yes, ma'am.
And Mr. Paredes is on probation in cause numbers 16-24053, that one for prohibited weapon possession, 20-35328 for aggravated assault causing serious bodily injury, and 20-35329, also aggravated assault causing serious bodily injury. Was in court previously. Entered pleas of true to counts 1, 2, 3, and 6. I've received an updated pre-sentence report. Have you both had an opportunity to review that report?
Yes, Your Honor. Yes, Judge.
Any additions or corrections?
None from the court.
Any testimony with regard to any of the other allegations? Mr. Smith?
Judge, we have persons here for.
I'm sorry, I can't hear you.
We had the probation officer here. If you'd like to hear from him, I believe that, yes, I did address.
I mean, I have what he put in here, but I just am asking if there's any witness, if you want to put in on any testimony for the counts that were not pled true to or not.
It's up to you.
I would ask him a few questions if the state's not going to call him.
So I guess we will do.
All right, Mr. Patton, if you'll please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Go ahead.
Mr. Paredes was ordered to perform community service, and has he completed all of that and provided verification to the probation department?
He is not, no.
And did he appear for alcohol or drug screening on June 18th, June 25th, July 2nd, July 5th, July 21st, 2025?
What were those dates again?
June 18th, June 25th, July 2nd, July 5th, July 21st, 2025.
So June the 18th, he did not show. June the 25th, he did not show. July 5th, he did not show. Then July 21st, he did not show.
That's what it's.
I guess I want to know with regard to community service, obviously what has he done out of any of it, if any?
Your Honor, in cause number 16-24053, he has completed 169 hours out of the originally assessed 300,
Okay.
which leaves him with 131. He last performed community service on April 4th of this year. He worked with our work crew at my Beaumont office. He has not performed any of the community service in either of the other two cause numbers.
Okay, thank you. Mr. Kimler?
Shouldn't the community service be concurrent in all three of the cases? In other words, the community service that he's done in one case should transfer and be credited against community service required in the other cases?
It is, yes, you're correct.
So he would have 169 hours in each of the three cases?
Yes.
Credit, is that right?
Yes.
And is that so even though he was already on probation on one and then we gave him probation on two after that?
It is typically how we do that, Your Honor. We typically will give them credit for community supervision on any of the cases they're doing for us, regardless of when they started supervision.
Community service.
Yes. Sorry.
May I proceed, John?
Yeah.
How long have you supervised him, Mr. Patton?
So I'm a unit supervisor at our department. I've seen Mr. Paredes on numerous occasions for administrative hearings, case staffings, and when I've held down a caseload when we've been in between officers.
Because you have some familiarity with him.
I do, yes, sir.
And during the times that you supervised him directly, has he maintained proper demeanor with him?
Yes, sir. Yes.
Proper decorum, all those things?
That is correct, yes, sir.
And should he be continuing on probation, he would not be the supervising officer, that would be someone else, is that right?
That is correct. I would not be supervising him.
Well, let's say, I suppose you acted as a supervising officer at some point in your career at the probation department, is that right?
That is correct, yes, sir.
Assuming, let's just speak hypothetically, if you were a supervising officer again, would there be anything about Mr. Paredes that would cause concern to continue to supervise him as far as his demeanor and decorum and attitude towards the probation department or personnel?
Hypothetically, no, not concerning those items.
Who was his supervising officer?
His supervising officer was Alexandra Ariano. Ms. Ariano went out on maternity leave and elected to stay home with her child. And so we've since filled that vacancy with a new officer.
But she was the one that was, I guess, directly supervising.
That is correct, yes, sir.
You had access to her records, is that right?
I do, yes, sir.
Is there any indications in there about some type of mental health referral, anything of that nature?
No, sir, there's not. Not that I've come across.
And nothing in the records that indicate that there's ever been any type of mental health assessment or mental health recommendation for Mr. Paredes, particularly not for schizophrenia or anything like that, but perhaps depression or?
Not that I've come across, no, sir.
That's what it is.
No further questions.
All right. So, Mr. Paredes, it shows here in this updated pre-sentence report that one of the things you told Mr. Patton was that you had been on probation since you were 18 and you just couldn't do it anymore.
Yes, ma'am.
That's true. And then you said, I'll take a safe P. I feel like prison's going to make me worse and blah, 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 but I feel safe P is the best thing for you. So tell me what you're asking for and tell me why.
Well, at the time when I told him that I couldn't take probation anymore, that was one of the times where I was just feeling real down and depressed, from everything that's going on in the past, with me being shot and stuff like that. I was shot in my neck and my arm. So since then, I've been having real bad PTSD, real bad depression, bipolarness. So, there's some days where I'm good, some days I'm not. Some days I wake up on the wrong side of the bed from having nightmares, and some days I'm just as happy as I can be. So from that point on, at this point, I know since being in jail now, this isn't what I want because it's just hurting my family, hurting my daughter, and being around the people that's around me, being around murderers and rapists and, aggravated robberies and all that. It's just a bad environment for me, and it puts me in a bad mood, puts me, in a bad mindset, I guess you can say. And I did speak with the counselor I had that they assigned me for probation, and I did tell her those things, and they did recommend MHMR, but I never went just because I felt like it was I felt kind of low, of thinking I would go to MHMR, because
Stigmatized.
Yes, sir. So at this point, I don't want to go to jail or prison. Feel like being in here, sitting in here, has helped me realize that my life is on the line and it isn't a game and it isn't a joke. And but I do need help mentally. I was prescribed Zoloft the last time I was in here due to my PTSD, but I never took it. Because I heard really bad things about it. But now I'm starting to realize maybe I should be on Zoloft just to control the urge of smoking weed and that kind of behavior.
I could ask him a few questions, Ron.
Sure.
I'm
Wait,
sorry, Ron.
best you can, raise your right hand. Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Go ahead.
Explain those facial tattoos to the judge.
This tattoo right here is my daughter's birthday, 11/14/2017, and this is 9/16/22 is the day my cousin killed himself. He shot himself in the head. This was right after my uncle had passed of cancer, and my cousin who just passed away, his dad, my other uncle, had just passed due to cancer as well. That's why I turned myself in a week later after my warrant had came out. This tattoo on here is a heart and a music note. I got that for my ex-girlfriend, being dumb at the time.
No gang affiliation.
No gang affiliated tattoos on me.
And you did turn yourself in on the warrant?
Yes, sir. I did turn myself in.
How are you maintaining employment when you're out?
I always held a job. Even if it's working at Whataburger.
What was your last job?
Shipley's Donuts was my last job to maintain, because I got laid off. I was with Bechtel. I was a carpenter for Bechtel for about 1.5 years.
At the LNG plant?
Yes, sir.
LNG terminal?
Yes, sir.
What were you out there, a carpenter?
Yes, sir.
Scaffold builder, what were you?
We were doing woodwork, building decks and carports. had lunch since in that nature.
And as far as being shot, that actually, I know the court, in looking at his criminal history, these are serious cases as far as the aggravated assault, serious bodily injury. You were actually shot during that interchange, is that
Yes,
right,
sir.
by the other people?
Yes, sir.
And you had returned fire?
Yes, sir.
That's not what,
I understand, Your Honor, but it's not, I don't want the court to think, I'm just looking at it, and I'm not trying
my
to.
understanding from the version in the pre-sentence report previously, and
I didn't represent him.
my recollection of it actually, because it's not good when I remember you. The fact that you were already on probation for a felony,
Right.
and then you came in and you admitted that you went there to shoot, you went there to go shoot Christy, which is your child's mother, right? That's not true? No? So did you mean to go shoot the two girls that got shot, Alexis and Taylor?
No, man.
Who'd you mean to shoot?
I didn't go there to shoot anybody.
I think as he explained it to me, he was going there to meet for sexual purposes the two girls, and when he got there, he was set up in the parking lot, and then by other people there, by people who were gonna rob him, and in the course of that, there was a gunfight, but he wasn't going there to shoot anybody.
All right, well, that's.
He was going there for an illegal purpose,
That goes against everything that was said and everything that he agreed to back then, because,
That's correct, Judge. We were getting ready for trial on this case.
Yes.
He was the aggressor. He was the one that fired first, and had he been a better shot, Alexis and or Taylor might have been killed, but he was there to go kill Christy.
I didn't represent him on
okay.
that, so I don't know.
All right. Anything else? All right, Mr. Smith, argument?
Judge, I would agree with the probation that I believe he's only asking for safety now simply because it's the only alternative he sees to prison. I don't think he's sincere about it. We have given him chance after chance after chance, and he has squandered, wasted, and even though he's a nice guy when he shows up, he does what he wants to do. That's evidenced by the jail reports that shows that they tell him to go back to his bunk and he just gets in the shower with his jumper on. And then when they write him up about it, then he says, man, fuck you. He has zero respect for authority or doing what's right, what he's supposed to do. I think prison term is appropriate in this case. The PTSD excuse is weak. He was the aggressor in the initial contact. And you can't claim that, well, I feel bad because I got shot by somebody who was defending two other women. So I would ask for pen time in this case.
Anything else, Mr. Kimler?
Well, it's difficult for me to address always with these jail incident reports without having the opportunity to cross-examine the person that made the allegations. So I would ask the court to consider the fact that that's not subject to, those allegations aren't subject to the rigors of cross-examination. But I think that on Mr. Brady's behalf, struggling with depression is a serious matter, and I know, and I respect Mr. Smith's looking at this as a way of somebody just volitionally, or somebody just deciding to be stubborn and self-centered and not complying, but depression's a serious problem. He has struggled with that. I think that's indicated by the limited mental history that we have. There is no new offense allegations in this. These are administrative violations. Of course, those are important, especially reporting. But because of the seriousness of these cases, I would ask that the court give him at least one more chance with the aid of mental health, maybe safety, but also as a follow-up if he gets out, to follow up with Spindletop to address not only any substance abuse problems, but any underlying mental health issues that may contribute to the substance abuse and just his ability to comply and just to continue on probation.
All right, thank you, Mr. Kimler. So, Mr. Paredes, the thing is, you've been given exactly what Mr. Kimler is asking for. You've already been given that. You said it yourself. They recommended Spindletop. They recommended medications. You made conscious decisions not to follow through with what they knew was best for you, which is part of your probation. Everything that they say you should do is a court order. The fact that you are on a probation from for possession of a prohibited weapon, like you said, from back when you were 18 years old. Put you on a probation, 10-year deferred for that, November of 2016. Then we're back here, you're put on probation for 10 deferred on 2 aggravated assault causing serious bodily injuries in March of 2022 for shooting 2 girls. And you got shot in self-defense. And it appears that there's no real reason for me not to believe that that's how it happened for a number of reasons. No one else was charged with aggravated assault for shooting you. All the police reports, everything that went through in those pre-sentence reports previously that I have copies of, all makes it appear to be true that you went there to shoot either Christy and or whoever else. And luckily were not a good shot. One of the girls got shot 3 times and survived it. And for you to say you have PTSD from getting shot, I can't imagine what she has. I feel like you've been given every opportunity. And when I look back on some of these times where I give chances like I gave you, it's very frustrating and a little embarrassing because it looks like I was not really thinking clearly then. I understand that these are drug allegations. You've been getting opportunities to get help. I mean, you've been on probation since 2016. With every opportunity possible. So at this time, in cause number 16-24053, I'm going to, also based on the evidence presented today, I am going to find count 5 true. So that makes you pled true to counts 1, 2, 3, and 6. I'm finding count 5 true based on that evidence in each of the cases. Find sufficient evidence in that case to find you guilty, and at this time find you guilty of possession of a prohibited weapon. Sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 20-35329, also find counts 1, 2, 3, and 6 that you pled true to those freely and voluntarily. Find them true. Also find count 5 true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault causing serious bodily injury. Sentence you to a term of 12 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon in that case. In cause number 20-35328, again, find that you pled true to counts 1, 2, 3, and 6 freely and voluntarily. Find those counts true. Make a finding of count 5 true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault causing serious bodily injury. Sentence you to a term of 12 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will also be an affirmative finding of a deadly weapon in that case. All 3 of these will run concurrently, which means together at the same time. I am going to hand you a trial court certification. These were not agreements. You do have some rights to appeal. You can talk to Mr. Kimler about that. I need you both to sign and fill out the bottom, and you'll get a copy. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. All right. I'm sorry?
It was 7,
12 and 12.
12, and 12.
Affirmative finding of deadly weapon on both of the 2 cases. One of those is for him. You're Lively Stratton Jr.? And so, Mr. Stratton, in cause number 19-33601, charged with capital murder, and this, we're back again on this. Mr. Radford has been appointed to represent Mr. Stratton. And Mr. Radford, have you had an opportunity to get started on discovery?
Judge, I have gotten a transcript. I've got a huge trial docket coming up in the next 2 months, and I haven't had a chance to read it. I have also visited with Mr. Stratton. I've gotten discovery from Ms. I've gotten the paper discovery
Okay.
from Ms. Malfino, and we have visited preliminary, excuse me.
Easy for you to say.
Initially, about a possible resolution to this case that doesn't involve trial, but we're going to have to do some further negotiations, and I think she has to visit with some family members.
Sure. And I know there's probably also some video and things
Yeah, I
that you
haven't
need to
got-
get.
Yeah, I haven't gotten any.
So obviously, Mr. Stratton is going to take Mr. Radford just a little bit of time to get up to speed on this. And so what I'll do
We've
based
been
on,
working to recreate the file, Judge. It just was in several different places, including the district clerk's possession. I have prepared a written notice asking them for the trial evidence to be returned to the possession of the state.
Okay.
I also have the transcript thing.
I've gotten the transcript.
To Ms. Tanner, and we will begin going through that and recreating the file. If there's anything additional Mr. Radford needs, he knows I have an open door.
Judge, could I get 60 days on this?
well, I was thinking for sure 60.
Yeah.
I mean, I think realistically, obviously, it's going to take you some time to get up to speed, get the file recreated. We don't want to put it off too long. We need to get it taken care of, but I know everybody needs some time. So we're in August. We're in September. We're not in August anymore.
I've got 4 huge trials.
Well, so why don't we do this? Why don't we come back first part of December, which is about 70 days, 75
Right.
days-ish. Let's find out where we are. And at that point, if you guys could at least have an idea if it's going to trial, then we can get a special date next year so that everybody's ready and available. And we'll get it set at that point if we need to for trial.
Yes, ma'am.
Okay? All right. Thank you. You can go back with the bailiff. Good morning, you're Adam Moe? Okay, so we're here because Mr. Moe is on probation for I did a different type thing where Mr. Moe went and did some time on some of his cases in prison, got out and is now on probation. Apparently, there are some potential issues with regard to where he's living that weren't issues with parole, but are issues with probation. Is that correct?
It sounds like they may be issues with probation.
Okay.
That's kind of why our original emergency motion had a strange title, because we didn't know what else to call this.
Sure.
Other than in an effort to make sure that he is doing everything correctly. I think our mission on that was, let's get in front of the court and make sure this is being done correctly.
So what's the issue, potentially?
Adam's parents, Jody and Chris Moe, who the court may remember, and they're present again today, while Adam was incarcerated, went to a number of lengths with the folks from parole to make sure that any home that Adam was going to live in upon his release and beginning the out of prison portion of probation and parole, because he's on parole too.
Correct.
That their home where he was going to live was in compliance.
Right. Parole's approved it.
Parole has approved it.
So where are we?
If the court doesn't mind, I'd rather not say the address.
No, I don't need that. I just need to know what the issue is with
The
probation.
issue is we are at 574 feet from a church that has a playground attached to it. And I don't want to speak for probation at all, but condition, I think it's 33, it isn't vague, but it's neither inclusive nor exhaustive. So I don't know exactly what the conversation was that probation had with Adam the day that he reported immediately upon his release from prison a couple weeks ago. And I don't believe that the conversation was, hey, you can't live there. It was, this is kind of an issue. So our position is a lot of effort was made.
So what's the issue?
Excuse me. So his condition number 33 says that he's not to be within 1,000 feet of places where children commonly gather.
Right.
So it's not limited to that list. And so I believe it's the 574 feet from the church with the playground attached is the issue.
Okay. I'm looking at the order now. Mr. Hoffpower, any strong feelings one way or the other?
Judge, we'll leave it to discretion of the court. I understand what probation is worried about.
Sure.
They set them up to fail. I do understand that's unique with parole and probation, two different entities, but
Well, and the
I don't want to
offenses
violate it.
were possession of child pornography.
Correct.
There weren't any allegations of
There were 10,
assaults or anything like
correct,
that? Okay.
just 10 charges of possession. And 5, we put 5, got penitentiary and 5 with probation.
Right. Is there a GPS at this point?
No, see, he hasn't had his initial, actually, Ms. Simon is tomorrow. He just did intake and correct me if
Sure.
I'm wrong. He just did.
No, and I appreciate being proactive, and that is good. We don't want to be in here the first month because there's a violation, which technically that would be a violation. There's no doubt that it's not vague. That would for sure be a
No,
violation.
in my reading too, on the geography of this thing, Judge, is that if Adam were to make, I'm going to call it a left turn if I've got the map correct in my head, if he were even to turn incorrectly down the main street where this house is, that would be a parole violation. So our position is that parole's assessment here, and I know the numbers are what they are, but that it covers both issues. So it's not like there's some kind of leeway to go even closer to that facility. He isn't going that way. He cannot, or he's in violation of what's been set up for with parole.
Judge, Ms. Roach says if he lived there, he'd be sentenced to his grandfather.
He's not, though. They specifically moved to
Okay,
thank you, though.
yes.
Ms. Roach is watching to make sure, because if you were living somewhere already, there's kind of a grandfathered in, but they specifically moved to try to make it better, and,
This one.
okay. Well, here's what I'll do. I will allow a modification of number 33. But I want it to somehow, some type of addendum or attachment that's very specific, because this isn't going to be a exception for all, only for this specific. So I will need probably the address of that church, so that in the orders, it says that you can be within 574 feet of that specific place. 33 stays the same for everywhere else. So it can be 33 can read like it does, and then you can add with the exception of that one place. Also, at least for, I would say, 6 months or so, or depending on how probation feels once he gets going, and if he's following all the rules and treatment and things like that with the LSOTP and all of that stuff, then I want a GPS monitoring device on at least for a minimum of 6 months to make sure that the rules are being followed, that he's going the right way, and there's not any issues. And that way, once we're all more comfortable with how things are going now that he's out of prison, then I'm okay with getting rid of that once you're okay with that, if he's following through with treatment and everything like that. Make sense? Okay?
Just one question. I think there's not school.
It's not the school issue, it's just the church.
The church. Yeah, the church with the, so I want that, that's the only exception, and the exception is the 574. So like you said, turn the other way, don't get any closer than what you're saying. That way there won't be an issue with it being any closer than what you're saying at any times that it would show up on that GPS. Make sense? Okay?
Yes.
All right, thanks. Y'all are free to go. No, ma'am.